Good morning. This is the New York City Board of Standards and Appeals Public Review Session for June 2nd, 2020. This is the 10 a.m. session. Once again, this is a review session. No public testimony will be permitted during the review session, so please do not call in. The first item is special order calendar, new cases. Item number 19, 7299 BZ, 1633 Manhattan, 6033 Broadway, Manhattan, sir.
This will be a little redundant for people, but I need to do this for the record. We have proof of service of initial application to officials. This case was originally properly noticed to officials for the March 17th hearing, which we had to postpone and renotice. It was also posted in the lobby for that date. It has been renoticed for this hearing with teleconference dial-in information. I don't believe it was posted in the lobby for this date because, as we discussed yesterday, there's sort of no one to see it, even if it were posted. We don't have any letters from neighbors in favor or opposition, to my knowledge. We're still waiting for a community board review, but this was filed on November 18th. 2019. So really the community board should have had time to review it within the 60 days, which was very much pre, city shutdown. We do have fire department letter of no objection. This PCE entered via a flight of stairs into a sunken plaza. The drawings state that it complies with ADA requirements, but I don't see how. I've been inside of this gym and I'm not aware of another way to get there other than going down a very large flight of stairs from the outside. So not sure how that works. I also, on the drawings, only see one means of egress from the cellar. So there's obviously another one somewhere. They need to show on the plans to where both means of egress to the street. And I just want to verify, because that's what it says in the statement of facts, that there's no Sunday operation, which is hard to believe given the location.
Because I unfortunately we discussed this yesterday, right. The applicant did make a submission, so I'm sure you have not seen it yet.
We can't consider the submissions that, it's hard enough when we were doing it in public in-person hearings, but it's impossible for us to review things like this on the fly. And applicants really do need to understand that we're working under very extraordinary circumstances this way, and they have to work with us, and they can't assume that we're going to be able to review things in 2 minutes and then sit around a table, which we can't do, to discuss whether everything is in order. So if a submission is made the day before, we won't review it until the next hearing or until in advance of the next hearing.
Okay. No, he understands.
Yeah. Okay. So then I'd like to ask Commissioner Shanda to unmute herself.
Okay. So my question is with regards to what is the total number of massage therapists operating at this location?
That's the only question. Okay.
Yeah.
Okay. And Commissioner Otley-Brown?
Yes, I agree with you that they need to show the ADA access on the plans. I did take a look at the plans when they came in before you stated disregard, and I did see that they have ADA access pointed out on the plans, so that when we do actually review it for the next hearing, it is there. Out of the 4 massage licenses submitted, 1 has expired January 2020.
Mm-hmm. Okay. Mm-hmm.
And that's all I have to say on that.
Okay, great. Okay, thanks. And then Commissioner Sheta, you're muted, so unmute yourself. Yeah.
Thank you, Chair. In addition to what is said, the only thing I have is when I looked at the PDF with the massage license, the first page was kind of blurry. We just want to be like flat. Yesterday, we told one of the applicants that if he sees something that's blurry and it's not crystal clear, he shouldn't submit it to us. Same thing here. So I would urge the applicant to take a look at the PDF with the massage license, page 1, and replace that page if possible.
Okay, well, submit the whole thing again because we don't want to get a little piece here and a little piece.
Yeah, of course.
Yeah. Okay. And Commissioner Shabeta?
Nothing further from me.
Okay.
Okay, next one.
Yes.
Appeals calendar, item number 20, 2018-68B, 68A through 2018-90A. This is Santina Drive, Staten Island.
Okay.
There was an email from DCP that the applicant submitted. I don't know if everyone
Yeah.
saw it. Yeah.
Yeah. Well, that was last week, right? It
Yeah.
just happened just now, right?
No, last week, sorry.
Yeah,
I
okay.
just want to make sure everybody saw it.
Okay, there's someone in the waiting room, Luba Senatorova. This is a review session. Please don't call in until we call your case. This is review and no public is invited to speak. The materials that were submitted to city planning for city planning's review were submitted to us and include city planning's January 17, 2019 comment letter. One includes the applicant includes a long and rather confusing discussion about the homeowners association agreements and the easements, which I did not try to unpack. It just kind of seems to be making excuses for why those would be fine. I caution the applicant to be responsive to this board's concerns about the HOAs and easements in their responses to city planning, and not merely provide reasons for not doing what is requested. So excuses aren't really a very useful way of proceeding on any applications. City planning had the following to say about the project in January, which I think was misrepresented by the applicant in its cover letter. They said, as the proposed lots and future development are reliant on private road access, and as private roads require the approval of the Board of Standards and Appeals to ensure compliance with the general city law, city planning advises that it is concerned with the City Planning Commission's ability to find that the proposed lots and future development may not meet the zoning resolution or the objectives of the South Richmond Plan in the absence of assurances over how safe and legal access will be provided. And then they go on to say the department has significant concerns regarding the proposed subdivision plan and future developments compliance with the South Richmond Plan, which obviously has nothing to do with the BSA. So I don't know if it's between a rock and a hard place, but one of the things that city planning suggested, and I'll go on. So city planning then sent a follow-up email on Friday, just this past Friday, May 29th, indicating that they would effectively welcome a mapping action to solve the issue of legal street frontage, which is different than what we've been hearing from the applicant community. So they would welcome a mapping action. And also that, as we know, CPC has not resumed its meetings to review completed applications. The project needs CPC subdivision and school seat approval. So they actually, I guess I won't read it, but that's the gist of it, that they would welcome a mapping action. So it's not that the applicant must come to the BSA. A mapping action is also a possibility. And since there needs to be subdivision and school seat approval, which is still in process, it seems like city planning is not doing what we've heard them do in the past, which is saying, we can't deal with this, go to the BSA. Instead, they're saying, we can also do a mapping action. You also have the alternative to go to the BSA. And like so many of these proposed private roads, the road width is inadequate to allow parking and passage of emergency vehicles and places all of the onus on the HOA to enforce no parking regulations, which, as we know, they rarely, if ever, do. So that's not a solution. We've learned our lesson, and without DOT or police department or fire department enforcement, the so-called restriction in the form of a restrictive declaration and some signs that are maybe posted that are maybe either installed or maintained or not maintained, that those are meaningless. So even if city planning were to approve the application for just the school seats and subdivisions, and even if BSA were to find a hardship here, I need some information or some recommendation about what is a believable, enforceable, viable solution to this problem, which the applicant hasn't given us. Now, they had originally asked to adjourn this hearing, but I asked them to come and give us a status report. So that's why they submitted all this material. So they're still working through the city planning review and don't necessarily need to debate this, but this is really a status report. So I'll go now to Commissioner Shanda. Unmute yourself.
Yes, I think the recent submission that has been submitted has still not addressed my concerns. And so far, the documents definitely have not given me any level of comfort or clarity as to how the layers of multiple HOA will be maintained, accessed, abided by, who will be responsible collectively, and how will even a city agency or FDNY will be able to navigate these multiple layers of HOA in a time of crisis. I don't think this layering of HOA is a solution to just physically connect the lines. It has to be done literally and in a manner where one can easily do it without having to read through the fine prints and see, do I need to contact Mr. X or do I need to contact Mrs. Y? It should not come to that.
Right. When you say literally, you mean physically or?
Physically.
Yeah.
Sorry, literally, I mean physically. One should not have to go through hoops to determine whose road I'm going on when I'm trying to save someone. So, or even for someone who is visiting a friend and not realizing that one is effectively on someone else's property that they shouldn't be. So I think this layer of HOA here is very confusing, unlike others I've seen. And I'm not sure this is a solution.
Okay. Commissioner Otley Brown, thank you. Unmute yourself.
I think it's problematic when the only access is through property that you don't own and you have to rely on a third-party agreement in order to access it. Because what would happen if the other homeowners withdraw from the access agreement? There's no way to ensure that you would have legal access to this property. So, you know, I think that and I usually don't come out in disapproval for a project like this, but this is a case where this is raising red flags for me.
Mm-hmm.
And I still don't see the hardship argument in the paperwork.
I don't think that they were actually, that's why I was asking for an update. I don't think that they were actually coming to us to continue that argument, but I agree with you, there isn't any. So, okay, Commissioner Sheta.
Thank you, Chair. The only thing I would say is, like Commissioner Otley Brown said, the hardship argument, that was one of my comments during the past hearing, is not there yet. And I understand that probably they are waiting to finalize the statement when they are done with the CP review. So other than that, I have nothing else to add.
Okay. And Commissioner Shabeta, thank you.
I was unaware that this was a status update. Most of my comments are about the different ways that this project is incomplete. Obviously, the lack of a hardship argument, or many of the other questions that we asked during our last hearing. I want to echo some of this. I won't be repetitive, but I echo the statements about the access and the lack of what seems to be a credible, discernible plan moving forward. But again, if this is solely a status update on where they are, I'm going to reserve my comments on the finality of this application. But again, I'll echo my comments from Beth. I don't believe that there is, I don't believe a hardship argument can be made here because of the particulars on this in this application. But again, just a status update. So.
Okay, and I just want to say, and one of the reasons I'm saying this is because this is like, maybe it's the 4th week of your property class in law school, which you take in your very first year, I think, of law school. You're taught that it's not possible to sell landlocked land, that there is an implied easement allowing access to landlocked land. So, you know, we've had this experience on Staten Island before where the lawyers, the real estate lawyers who are representing the property owner don't seem to have remembered Property 101, and they don't pursue. So it seems to me that whoever was the seller of that property, or even if this is the same property owner, if they sold off the frontage, they sold it with an implied easement of access, right? So that's basic. And if you sold off a landlocked piece of property, it was sold with an implied easement of access. Where the access is another thing. Maybe it isn't on Santina, or what's the other name of that the other one, Darien or something like
Hogan?
that. Sorry?
I think it's Hogan's on the other side.
Yeah, the one that's on the opposite side of Santina. It may be right down the center of all of that space in between, right? But this requires somebody to do some serious research about the history of the transfer of property. And we often find that the title companies just don't really do their work and don't do the research. So in their place, I would go back into the distant past about the history of this site and find out how it was conveyed, because you cannot convey something that's landlocked.
And I think that if for a viable hardship argument, I would need to know how this property was, this lot was formed to say whether or not this was a self-created issue.
Right. Well, that's another subject, right? I mean, yeah. Okay, understood. All right, thank you.
Thank you, Chair.
Okay, Tony.
Okay, the next item is item 21, 2019-68A, 235 Industrial Loop, Staten Island. It's another GCL.
Sorry.
This is still a review session, no public testimony.
Okay. In this case, the applicant was responsive to the comments about the maintenance of Derrick Court and the sidewalk continuity. So I'm okay with this, and we had, yeah, and we're okay with seeker, is my understanding. So Commissioner Shanda, sorry.
No, I did not have any comments, but did we get any sign up from DEP and FDNY? I wasn't able to locate any sign off.
I think we still need FDNY. DEP, I'll check, but I thought I had.
Yeah, okay. I don't see it either. Okay, so, and Commissioner Otley Brown?
I have no comments.
Okay. Commissioner Sheta?
Yeah, I have FDNY, and
Oh.
that's it. I haven't seen the fire department approval or sign off. And
Okay.
apart from that, I see that they revised the statement of facts. They corrected the FAR, and I'm okay with the application as it is right now.
Okay. And Commissioner Shibeta?
I hope they gave us the FDNY approval today. So this, because I don't have any issues with this application.
Okay, but DEP,
We're still missing DEP as well?
yeah, so I'm not sure. Ken we'll look at it in the break or, not the.
Yeah,
break.
I'll take a look, but I don't think so. What is this?
Yeah, I'll take a look as we go, as we can move into the hearing then.
Is that John? I'm sorry, I got a text message. The department is considering enforcement actions if I don't know what that is.
I have, the only letter, at least I'm seeing on file, is from June 12th, 2018,
And what is
from
it?
DEP. And it says DEP will continue to review upon receiving required documents. And at that time, the applicant was asked to submit a site connection proposal.
Yes, I'm sorry. Yes, I'm sorry. Yes. Site connection
So
proposal.
there isn't anything in file, of any other follow-up communications.
All right, I'll follow up that. I'll check. I thought we had something else. I apologize.
Okay, and the applicant could maybe help us with that. Maybe it's. just
Right. And I
hidden-
don't think we need a DOT anything on this because,
DOT, if it's a GCL 36, DOT is not gonna.
right, okay.
Right, and then my question had been about sidewalk continuity, and I thought the explanation was reasonable for why the
Yeah.
sidewalk does what it does.
Okay.
Yeah.
But you know, part of the thing is maybe somewhere hidden or attached to some other document are these sign-offs, but at the moment I don't.
Yeah, I apologize. I will double check.
Okay,
All righty, so that, just make sure. So that concludes the, anyone else? That's it? Okay, so that concludes the public review session. We'll now commence with the public hearing. So this is the public hearing for June 2nd, 2020 at 10 a.m. So the first case is 7299 BC, 1633 Broadway, Manhattan. So you may call in, Mr. Dale. Oh, what did I do?
so what, did you already ping him, text him?
Yeah, for some reason, it's not allowing me to do this text. Oh, here it is. Sorry.
Okay, this is 72-99 BZ, 1633 Broadway. Please call in. This is the public hearing and we're waiting for the applicant to call in. Any success? Tony, you're muted.
Sorry. I muted because I was checking and he answered back to me. He said the YouTube video didn't start till 10:15, so he missed it, but he's calling in now. I think he was trying to update.
So, oh, there he is. So,
Yeah.
so that's something, somebody in our group is supposed to be watching to make sure that the video is streaming properly.
Good morning, Todd Dale.
Good morning.
Sorry, the YouTube video was like 15 minutes behind, just so you know.
15 minutes time delay, or it didn't start?
When I was trying to refresh to watch the YouTube video, it did not start streaming until 10:15. So I was trying to catch up. So I apologize for being late, but there must be some gap between once it started and once it's actually available on YouTube.
Okay, we'll check that. We really need to have one person in our team who's watching the video, which probably should be Steve, to make sure that it's actually running properly.
Oh, when Tony announced the when it started, that's when it started streaming on YouTube itself. When Tony announced it was streaming.
It was streaming. You
When
were
Tony announced,
watching it on YouTube streaming?
yeah, I had it right here. Up, looking at it right now.
Maybe Todd, it had something to do with your refresh.
Looking at it, I'm looking at it as well, and I believe it's up to date.
Yeah, but that's now. Todd was saying it didn't get started for 15 minutes until, right? Okay, anyway.
The timing right now is current, but in order to access it, I was not able to access it until
Oh, I see.
until 15 minutes. And I tried to fast forward as much as I could, but obviously didn't catch up. In any case,
Yeah, we just need to know these things so that we can try to fix them. So thank you. Okay. All right, go ahead. Tony, you need.
swearing in for this.
No, it's an A case. Oh, I'm sorry, it's a
No,
BZ.
no, it's a BZ, 7299 BZ.
Okay, so do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond on city board member questions?
I do affirm.
Okay, thank you.
So I heard the comments. I understand, the board needs more time to review, but we did try and make a quick submission last night to address many of the concerns that were raised. We would stand on that submission. I believe it is going to address the concerns once the board has time to review it. But just quickly on some of these items, we did submit the public assembly plans that were used for the PA permit. There is an approved PA permit that was previously submitted, but we submitted the public assembly plans and marked the ADA access and the egress on those to show. Just to provide some narrative, the ADA access is provided through the main building. Patrons requiring alternate access would enter in the ground floor, and then there's elevator access within the main building that would take them down to the cellar and a concourse level where they could enter the facility. With respect to egress, we did mark, you'll see on the plans, we submitted the plans, we tried to mark with arrows where the egress was. But with respect to egress, I would note that there is a PA permit and the fire department wouldn't issue the PA permit unless the egress was satisfactory. So.
Right. No,
Yeah.
no. The reason that I want to see it anyway on the drawings is I want it to be just really clear.
Sure.
I'm sure there's a second means of egress. This has been open for a very long time. So it's just that we want to see it on the plans.
Understood. I believe once you have time to review the plans, it should address the questions. If not, obviously we can respond further. With respect to the massage license, it is my understanding there's the 4 masseuses that we submitted the license for. We'll submit clearer licenses and confirm that number since this will require another hearing. With respect to the community board, just so the board is aware, Community Board 5 regularly will waive recommendation on renewals for PCEs. It is our belief that they intended to do it for this site also. This application was actually filed at the same time as the Rockefeller Center application that was reviewed yesterday. I reached out again to the community board yesterday, had a response back from them that they were going to look into the issue, but we would anticipate that they are going to issue a waiver of recommendation letter shortly, but we'll follow up with that.
Okay.
And I think the last question that was raised with respect to Sunday hours, this site was actually closed on Sunday. However, we in this last submission, which you have not had time to review, are actually requesting Sunday hours now to expand with the intent that under the current public health circumstances, the idea is that having expanded hours would allow more flexibility as far as, spreading out visits. So you'll see 7 to 7 Saturday and Sunday. And I believe it's 5 to 10 Monday through Thursday and 5 to 9 on Friday, but that is listed in the statement.
Okay.
There's a revised statement. And I think those were the core questions that were addressed.
Okay. So I'm just looking at the hours that you had in the statement before. In the statement before, it was Monday to Thursday, 5:30 a.m. to 10 p.m., Friday, 5:30 a.m. to 9 p.m., and Saturday, 9 a.m. to 6 p.m. So
Okay.
that's you've changed the hours significantly. That's okay. I just want to alert council, our council.
So the Saturday and Sunday hours will be changing, but we'll
Okay.
it's in the new statement that you have not yet had time to review.
Okay, good. All right. So any comments from commissioners? Chase, go ahead.
You stated that the elevator brings the public down to the concourse level. Is there access to the first cellar, because the lockers are only on the first cellar and not on the concourse level? So to the extent that ADA has accomplished their equivalency.
Let me look at the
that's
plan, but it should, the elevator should take them to both the first cellar and the concourse levels. On the plan that was recently submitted. I will double check right now. Of course, it's difficult for me to look at a plan that you don't have the
Yes.
ability to see. But yes, it takes to each of those levels. But when you see the plan, if there's any questions about the plan, we'll respond. But we believe that this PA plan that is marked will clearly show the access.
Mm-hmm. And Commissioner Otley Brown, did you have a question?
Oh, I was just gonna say, yes, there is elevator access to both floors, but
Okay.
Todd answered. Mr. Dale, sorry.
That is fine.
Okay, good, okay. All right, so given that the modifications, we know what they are, and the modifications are slight, I think we could close this, but first we have to invite members of the public to speak. So let's do that.
Okay, so this is 7299 BZ, 1633 Broadway, Manhattan. Who's
Okay.
only call for that case?
Right, so, Mr. Dale, you just need to give us a cleaner copy of the masseuse licenses. And I think that was it, right?
Yes, we'll do the new license, the cleaner copies, and then once Mr. Bell has a chance to take a look at the plans, or there's any questions about what we did submit, we can, respond or revise. But it's our belief that this last submission should answer all of the questions.
Okay. Okay, submission. Okay. Okay, so then I would like to make a motion. I don't see, hold on a second, let me just check. I don't see anyone calling in from the public. So then I'd like to make a motion to close this one.
Chair Promoter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Okay,
Does the dog have a vote? I don't know.
huh?
Does the dog have a vote? I'm not sure. We'll have to
Sorry.
check our rules. Because I think it was an aye. My dog Harlan.
Absolutely.
Rusty.
That was kind of cool.
We will gladly take the first 6-0 vote in history.
Okay.
Thank you.
Thank you. Thank you very much. Okay. All right.
Okay, the next item is Appeals Calendar 2018-68A through 2018-90A. This is Santina Drive, Staten Island.
We have Mike Santa in the waiting room.
He's the architect, he's the applicant.
Okay, he's related. So he was just admitted. More. There we go. When you can hear us, Mr. Santa, state your name.
Michael Santa, can you hear me?
Yes.
Okay.
Are you expecting anyone else?
No.
Okay, great. Okay, this is an A case, so you can just begin.
All right, very well. I listened to the review session prior to this, and I think there's a little bit of confusion, and maybe I can lend some additional information to that effect about the project. One of the commissioners had commented about the ability of the current HOA situation to permit access to all the homeowners, and that there may be confusion of FDNY, emergency services, to enter upon the land, whether or not that they felt like they had to negotiate through one of the HOAs. And the documents that have been submitted clearly indicate that Santina Drive is one roadway, okay, is provided connection between all the residents and is put in perpetuity for access. So there is no confusion about emergency services entering into the property. There are signs that have been already installed at Arbutus Avenue to show clearly where the entrance is to our to all the lots. And we also provided additional signage on Denise Court, which is the other roadway, as for the emergency services loop. So clarity has been placed in the plans in order to indicate that there should be no confusion on anybody's part about how you would enter the property, Santina Drive, and where the emergency services would be able to get in from two directions.
So
The way that yes.
I just need to clarify where we're coming from. So you're looking at it from an architectural perspective. The drawings look so clear. You go in this way, you maybe go out that way, something like that. We're looking at it from a legal perspective and who owns all of this property and who controls it. Because ultimately, if there is a failure to maintain the roadway, that's one issue. If there is an issue about trespass, all of that, the way it's structured right now, which is a bizarre structure, there are too many players and we don't even have all of the players participating. So there's one house that's not agreeing to amend the HOA. So that's effectively no amendment of the HOA. You can't partially amend it. And until this is one coherent HOA with one coherent easement agreement that makes it very clear to all comers, both emergency services and individual homeowners, it's not a workable solution. And as you probably know, Staten Island has terrible history with these unmaintained, kind of ignored areas where the people who are on these private roads don't even know that it's not the responsibility of the Department of Transportation to take care of their property. So you have a very big legal hurdle before us. And it's an architectural issue for me as well, because Santina Drive is very skinny. And our experience has, and the reason it's skinny is because you have this one house, I believe that's on lot, I can't tell if it's lot 60 or 17. Anyway, the lot that's fronting on Arbutus. The reason your access is narrow is because you have a house in the way. And so from an architectural perspective, you're expecting no one to park on that whole route going all the way down to the roundabout. And that's just not what we ever see. Somebody has a party and the cars overflow and you have a lot of houses there. So there's potential for a lot of parties. So
Well,
yeah. So,
can I make a statement to that? Part of the design was the majority of the homes that we're proposing, the 23 homes, are on a 38-foot roadway with parking on both sides of the street. And from those homes, it's quite distant to go down to the Arbutus Avenue. It's several hundred feet. So the people that would be occupying the new development have plenty of parking on the street.
Well,
there are only 3 homes that are on the 30-foot portion. All right. We didn't go to 34 feet. We went to 38 feet on that roadway in order to provide ample parking and a turnaround for those new homeowners. The 3 homeowners that are currently existing, that particular street was approved by the BSA, and those documents that were prepared did not have any parking restrictions at the time, except for on the roundabout. So there was no parking restrictions back when the BSA approved this case. So we took the position of, well, what does the fire department need? And we submitted a plan to the fire department and we proposed no parking on the 30-foot roadway. Well, the fire department needs for the 34-foot roadway at least 14 feet of clear path. And that's what they feel is necessary to be able to conduct fire operations. So in this case, we're proposing no parking on the entire 30-foot roadway.
We know.
Even if people during an event, let's say the person in that front house was to say, well, even though we're striping the street, we're doing all of these very physical and literal things on that roadway. Should someone park on that portion, that one side, we still have complete adequate width for fire operations features left over on the other side for the 30-foot roadway. So no matter what happens, you know, because the commentary is that signs, striping, apparently no matter what you do, it's physically not enough to be able to say that, how do we have a guarantee? Now,
Mr.
Yeah.
Sana, I think
Yes.
you just said something that is of concern to me, and I think that is what we are all struggling with, is, as you said, you know, maybe those in the new development won't be parking here. But even if you are putting up a sign that says no parking and someone ends up parking, the question becomes, who is monitoring it at the end of the day?
Okay.
Even though it may be wide, but it's a violation of the rules and regulations. And if one starts breaking these rules and regulations, there's no end to it.
Well, you know,
But go ahead, Commissioner Shabeta.
before we get into the minutia of this project, Mr. Sana, city planning clearly stated in their May 27th email to you that this should be mapped.
my comment to that is that
Is that true or not true? Because in your
no, they've asked based upon the current situation, meaning the current political situation, to be able to map this private road.
so that's not how I understood it when I read it, and I'll just give me a moment.
You're talking, Commissioner Shabeta, you're talking about the May 27th email?
I am.
Yeah, go ahead.
The May 27th email, I've had several lengthy discussions with city planning, and this letter is just a tidbit of information that comes about.
It says, based on your submission, the
Yes.
department's position is that in order to proceed with subdivision action, the street should be mapped.
Street should be mapped, or you go to
No.
the BSA for general city waiver.
Hold on. They say what they're saying. This is, you know, that is their recommendation. If you choose not to follow it, you can try to get a BSA waiver. But they stated very clearly, and I've read, at this point, I've read several emails and letters from city planning on the GCL 36 issue, and this is the clearest they've ever been on their position on having this mapped. So
Well,
I really don't know. If your client wants to, you know, continue this way, that letter for me is dispositive.
And
Well, I will tell you that, I will say that in order to map a street, a private road, which is a very rare occurrence, it usually has to connect to a mapped street. Arbutus Avenue is not mapped. The city never mapped the street. You
so,
cannot map a private road that doesn't go to a mapped street. I
so
don't think the Department of
city planning invited you to go for a mapping action, right? City planning is aware of the difficulties, and there isn't actually a rule that they're aware of the difficulties that are going on in Staten Island, and they're trying to address them. So they will compensate for those kinds of issues. But I agree that all of this should be handled at city planning because it has to do with proper planning of a site. But I also want to go back to your statement about ample parking on the main 38-foot wide roadway that's in front of all of the houses. You have really wide curb cuts. And the result is there's one parking space maybe between curb cuts on each between all of the curb cuts. So I didn't count the number of spaces, but essentially it allows each house to have one extra parking space. And in Staten Island, as we know, lots of people have more than one car. So you've already filled up your development with people who live there with their extra car, and there isn't room for the party unless we're talking about double parking on the street. And so of course it's going to spill into that area where parking is not permitted. That was the condition of fire department's kind of conditional okay with this, was that area be not permitted to have parking, which we know can never be enforced, is never enforced. There's no city agency that has the authority to enforce it. And so what I do have to say is I think you're at a disadvantage because you're approaching this from an architectural perspective, which is a completely different discipline from the legal perspective. And so you really need to be working with a real estate lawyer or a property lawyer to figure out how to put this together in a way that gives city planning comfort. They have the same objections as we do, that gives city planning or the BSA comfort that you can accomplish this in a way that's safe. But at the moment, this is, one of the most complicated structures of a GCL 36 waiver I think we've seen. Most of the time it's one owner, one easement, one HOA, that's it. And the failure will be that HOA failing as opposed to 3 HOAs failing.
Well,
So-
can I add, first off, there were only 2 HOAs, not 3. And the commentary about the parking is we have provided 2 cars in the side yard and a 1-car garage, which means there is an additional spot in the driveway in front of the garage. So there's literally 4 cars permitted to be parked. 3 are required and 1 is additional. So it's not that 4th car is not on the street. The 4th car is in the driveway. And we have purposely did this to provide additional parking for each and every one of the residences off-site. So the parking spot that is in front of the property is for the guest. So there are 4 spots.
Only one guest?
Well,
That's a small
assume-
party.
I understand. And if you have a party on that street, like any other street, mapped or otherwise, the street is 38 foot wide. If
We're
this,
not talking about the 38-foot wide street. We're talking about the narrow street that gets you there that must be kept clear of parking. That's your problem. It isn't the 38-foot wide frontage of all those houses, 2-family houses, right? Not to mention the fact, which community boards hate, right? You got tandem parking. So you have the same issue with, oh my God, my car is blocked. I can't get in, so I'm gonna park on the street.
well, I mean, we tried to address that by having the garage separate from the tandem parking spots on the side, and Community Board 3 has lauded that as being very positive. Their concern is the fact that you have all the cars, either a detached garage and then 2 cars in front of it, and everybody's got to back out. Well, in this case, we have 2 points of access, which is why the curb cut is 17 feet. So therefore, that if the apartment could park on the one side and the main unit has the garage and the driveway in front of it, and they don't conflict. So we have made attempts to be able to solve those issues, and Community Board 3 was very comfortable with that approach.
Mr. Sano, with all due respect, your statements that arguing for a GCL waiver, I find as more evidence that there shouldn't be one. The statement that, well, Iredibus isn't mapped, so I should create more waivers as opposed to trying to have proper planning that city planning is recommending, it doesn't convince me. And further, I do take exception to the dismissal of dismissal of city planning's position as political. They've recognized a problem, an issue that has been plaguing Staten Island that there is ample evidence of, and they're trying to address it. not merely some change of political opinion. This has been years in the making.
And I also want to say that I'm very confused about your statement about the community board. They recommend denial. And then they go through a really, which I read at one of the earlier hearings, a really, really detailed reasoning, rationale for why they oppose this. And their rationale calls on lots of other applications that they've seen or situations that they've seen. You know, they say generally after 15 to 25 years, the infrastructure problems become costly. Dry wells have a 20 to 40 year life. They just go on and on about the HOA, that they don't, the management agents aren't always effective, et cetera. They go on and they explain in enormous detail what the problems are with an HOA. And in this situation, you have, I count 3 HOAs because you have the one that's the existing 3 houses, the new collection of houses that you're proposing, and then the other one on that side route, which I'm not finding now on the drawings, on the side route, that Denise Court, that's run by a different HOA. So yes,
Yeah, but that HOA is not part of this application.
you need an easement in order to go over someone else's property. And
No,
if
this
someone
property
else-
is not part of the Denise Court. To give a little bit of background, I think that may help, is that this land, the lot that we're talking about, was originally a horse farm. And they had access, they had a strip of land that went all the way out to Arbutus Avenue. This was before Denise Court was built. This is before the house that's behind the Arbutus on Denise Court was built. So the individual property owner that owned this land had a neck of property that went out to Arbutus Avenue. That is the history of the site. When he sold, he used to live in that in that front house. When he subdivided off that piece, he created the easement that we're using now. That easement was in place long before these other developments were done. So that easement is number one. That's why the length of land that we have, and we have the right for the restrictive declaration, because Denise Court made a deal with to be able to use that 15-foot strip from this property owner for their purposes, and they're not part of the Denise Court HOA because they came first. So there is no third HOA that's involved here. It's simply this property owner had the rights to this access originally.
Okay, so you're talking about, go ahead, Commissioner.
Chair, I was just going to state my personal opinion, which I believe that unless you feel differently, because this was supposed to be a status update, I'm comfortable on voting on this at this point.
Okay, I don't want to jump to, let me see. Do we see,
I don't, you know,
we would close, so obviously we don't vote. But I don't want to jump to anything unless other commissioners believe that we've seen enough. And we had earlier, and I really think that you should be here with counsel. You're trying to handle legal issues, Mr. Sana, on your own. And it's really, yeah, it's kind of not your specialty, right? But I don't know what the other commissioners think, because we had directed your client to go to city planning and get approvals, right? City planning is now in a standstill, right? There's basically no projects are being reviewed. We don't know when they're going to start again. We're not going to act, and we never do until city planning makes its decision. I would recommend that you look into the mapping action, because you basically refuse to look at it. And so that's pretty confusing to us. You're making an argument for why you can't, why the mapping action isn't possible, but according to city planning, it's possible. They invited you. So in your place and in the owner's place, I recommend that you look into that.
May I ask a general question? I'm looking to, move this forward and provide whatever information would be comfortable for the commissioners. I'm not looking to battle points that I just think that a lot of the information that's been discussed at the review session is not really consistent with the documents that I submitted. There are questions about, the roadways and the HOAs, and we could work on that. I mean, Community Board 3 is concerned about all private roads. And personally, even if that was mapped, even if the private road was mapped, let's say DOT would approve a mapping of a private road that goes to a non-final map street, which I think is problematic in their typical approval process. And that would become a concern, and this project would have certainly be, should be able to get a waiver based upon that. I will also add,
Sorry, I don't understand. Based upon what that city planning isn't okay with it?
no, to the point that if DOT refuses or objects to the mapping of a private road that does not go to a final map street, and they're not willing to give their approval to that, then am I not open to a waiver here in this case?
I don't want to second guess the reactions of all those agencies that are involved in a mapping action. Commissioner Otley Brown has her hand up. Go ahead.
Unmute.
I think that given that city planning has introduced the idea of a mapping action here, I believe that you as the applicant have a responsibility to go research that situation and at least be able to report to the board what it actually would entail. What are the pitfalls, the possible pitfalls, if there are any? Because right now this is just conjecture on your part, which is really designed to support your application here. And that's not really advancing your application, because all of the commissioners have misgivings about this project and they're not being allayed.
Thank you. So, yeah, okay. So, right. So I don't know whether closing at this point is appropriate. I would just look for Tony doesn't think so. Okay. I would say, what, Tony?
I mean, maybe, he speak to one of the land use people.
Yeah, I'm concerned that you're not represented by counsel, or maybe you are, your client isn't. So maybe that's something you need, but the better course of action in addition is to go to city planning.
And to go to city planning. That was my second statement. Yeah.
So you have an open invitation from city planning. Accept their invitation. It's wonderful. It's so hospitable.
May I ask the question, if, let's say all this could be circumnavigated and they would map that street. Let's say they would map it.
Mr. Santa, I don't think we should go into hypotheticals.
I don't think we should, Mr. Santa. I think, you need to research this and discuss with one of the, we can't refer you to anybody, but there are some of the land use attorneys that have been dealing with these kind of cases. And maybe that's where you sort of look to or even consult. But also, city planning has thrown this out now into the open about the mapping, which the board has discussed with other applicants.
Yes.
So you're not singled out. It's just on these type of projects. So the more they review
project with so many
homes,
homes and yes, and significant problems. So okay,
I
so
will look into that. I will take that recommendation. I will discuss it with city planning, and I will discuss it with some additional consultants, and to see where that leads and get back to the board.
okay, great.
Yeah.
So I would like to, any other comments from commissioners? I'd like to invite, see if the public is interested in speaking on this. So go ahead, Tony, read the case.
Oh, I'm sorry. Once again, this is 2018 68A through 2018 90A, Santina Drive, Staten Island.
Okay. All right, so just to keep it still before us, I'm gonna put this off until, 6 months from now or something, to give you, Mr. Santa, time to reach out to consultants, city planning, and so on. The sooner you make the application to city planning for mapping in conjunction with the subdivision and the school seats, the sooner you'll potentially have a project. But city planning will look at this from a planning perspective, which is what they're supposed to do, right? And to determine whether, is that the right number of houses, is that the right layout, et cetera. They've expressed concerns about whether it's consistent with the special purpose district. We can't do that. So they have concerns about it. We don't really know what they are. And I recommend that you pursue them like that.
I
Okay.
will do so. I will just say to you that in speaking with city planning, besides that, the latest letter, which is given, that I have addressed all of their commentary about complying with the South Richmond district regulations. And this application complies with all of those. And they summarized it by saying that we have concerns about the roadway because it's not been approved by BSA or get a mapping. So that's the gist of it. All the other issues about lot sizes, about parking, about all of this is all been rectified. So
Actually, the other way, it says get a mapping action. Or if you choose not to, then try your luck with BSA.
But it also says the department has significant concerns, that's in a letter, not the email, significant concerns regarding the proposed subdivision plan and future developments compliance with the South Richmond plan. I don't know what those are. We don't have a letter from city planning saying, okay, we're not concerned anymore. We have this ongoing dialogue with city planning where the South Richmond plan seems not to be, that this project seems not to be consistent with that. We don't know what that means. So again, to stop repeating ourselves and circling, you need to go to city planning, try to get it all resolved there. In fact, get it all resolved there. And hire consultants who are up to the task of responding to city planning's concerns, which are similar to our concerns. Okay, so I thank you for calling in. Okay, thank you very much.
Okay, the next item is 2019 68A 235 Industrial Loop, Staten Island. Todd Dale?
how do I get out?
Let me text him again.
What happened?
I hit the,
There he is. He's here.
I got it. Okay. Little slow for me, sorry.
Good morning, everybody. This is Todd. Can you hear me?
Yep. State your full name now that you're here.
Todd Dale for the 2968A Industrial Loop application.
Okay. Go ahead.
So listening to review session, glad to hear that the board appears satisfied with the information that we provided. With respect to FDNY and DEP approvals or sign-offs, I was looking at my records. I don't know if I saw the fire department yet. I don't know. Tony, I believe this may have been your case. I don't know if you saw it either.
No, I don't have fire department, and I think fire department's going to speak on this, but I was just double checking my thing for DEP. I didn't.
And what about DEP, Mr. Dale?
All I know, I mean, as the board has handled many of these cases, you're familiar, there is a master plan that's approved for all of Industrial Loop. And the general process with a master plan is that sets forth the framework, and then each individual site connects pursuant to this previously set forth approval. There's an SCP that they obtain based on the master plan. So this is a bit different than some other sites where there is no groundwork already in place. I am not sure if the master plan was submitted for this particular application. You know, we have currently a few applications pending on Industrial Loop. I can double check. I don't know if that master plan will satisfy DEP, but it's a different situation than where that plan doesn't exist. There's 2 levels of approval, and the core approval is already completed. So if DEP has any comments, we're happy to address them. But because of the nature of this site, I would venture to say it's further along in any sort of review that DEP would need to make.
Sure. I mean, all the sewer systems and everything are in place. It's industrial.
Yes,
loop.
there's a water main in Industrial Loop, and then the sewer is not in Industrial Loop, but the plan connects to the there's a plan set up for the outer connection. I believe it's an Arthur Kill Road, and also I forget what the road is to the east, but I think that there's also sewers to the east.
Right.
Yeah, I emailed them again, just to check and see where they, any
Okay.
update. I'm sorry. Yeah.
Okay, so yes, please do submit the master plan. I'm just looking at what is this one?
No, he didn't submit the master plan. It's this, the SCP, right, Todd?
Oh,
It's 2 levels. I was actually just looking at my records. As you know, there's another case pending for, this is 235 Industrial Loop. Our office has another one pending for, I believe it's 195 Industrial Loop.
Right, which is next
We
week.
submitted the master plan for 195 Industrial Loop. We can submit it also for this particular case, but I am not an engineer. But I will speak to my understanding is that the master plan sets forth the phases and the overall plan for the development site. And then each individual lot has an SCP based on that prior master plan approval. So there is a master plan set up that is approved for the Industrial Loop Derrick Court site. It is not on the record for this application. We can submit it if the board wants for this particular application. And then I don't know if there's any particular DEP comments about this site above and beyond the usual things we provide for Industrial Loop applications.
right. But we didn't get anything from DEP since, when was it? 2018? You're muted, Commissioner Shanda.
That's right, 2018.
Okay, so yeah. so
2019, 2019.
19 or 18?
This case was filed in 2019.
19, oh, so it has to be 20.
Oh,
So when
then-
was, but it was still that they're continuing their review? Is that the last sentence on it?
Yeah,
Oh, okay. So we really do need a sign off in order to, or at least some, even if it's an email from them saying good to go, right? An email would be good enough.
Yeah.
But why don't you submit that master plan?
Sure.
And then maybe we can get an email from them.
Okay.
Okay.
We will submit that and we'll wait for any further comments from either the fire department or DEP.
Right, okay.
fire,
so-
fire department wants to speak.
Yeah. There you go.
Morning, Madam Chair, members of the board, Mr. Dale. On May 7th of this year, I had conducted an inspection at Industrial Loop and had videotaped my access onto Industrial Loop, which I then shared with the Bureau of Operations, the Borough Command for Staten Island, and right now they're up in arms. There is a security arm that obstructs access to the street, where a car can drive up, has to stop, the arm will go up, and then you can go through. But the fire department apparatus would be a very tight squeeze between the security arm. Mr. Dale mentioned the overall approved plan. Yes, I would like to get a copy of that. Another problem that we do have is that there was parking on both sides of the streets, going into and out of Industrial Loop. The fire department is trying to put together an enforcement unit to go and start issuing parking tickets. I had spoken to several people there, and they were like, "There's nothing you can do." So at this point right now, the fire department does object to this application. Unfortunately, we cannot do any enforcement action due to the current crisis that's going on in the city. Hopefully, things will be resolved. that we can. But at this time, we do object to this application.
Okay, I have a question about this generally because we get many industrial loop applications, right? Is this part of industrial loop different than some other parts? Is it narrower? Is it less organized?
It's the same development, but just it's less organized. They have personal vehicles, they have tow trucks, they have tractor trailers lined up on both sides of the street. It is very narrow. I mean, I have my car compared to a truck is narrower, but I had a difficult time navigating down that street. They do store a lot of other materials. I don't know what they are because I didn't do a physical inspection of each of the buildings there, but that's part of our enforcement task force that we're trying to create once the current crisis has been completed.
What, they store materials on the roadway?
Yes, there were barrels. I had to observe barrels. I don't know what's in them. There were combustible and a lot of flammable material stored haphazardly everywhere. I know on the exit route out of industrial loop, it's adjacent to a heavily wooded area. There, I was able to observe, a lot of debris back in that wooded area. And I know it's going to cause, it will cause a fire, but at this time, our enforcement actions are currently on hold. So, but at this point, I did want to make a verbal objection of this application, or to the whole development.
Right. I would like to recommend, and I think he probably knows, that Mr. Dale reach out to you to see what could be done to assuage fire department's concerns. Maybe there's something for this site, and maybe for neighbors, maybe working with neighbors to come up with some. There is it's not exactly an association. What is it? It's not a homeowners association. It's another kind of association that's responsible for this entire route.
It's like an Arthur Kill Road, something, but it includes some of these sites.
Association.
Yeah, so they're responsible to maintain, I think this, isn't they, Mr. Dale?
Yes, and how was this? We will, gladly review any information that's provided by the fire department inspector daily. My understanding, and you can correct me, is that arm gate is actually down by Arthur Kill Road.
Right.
So it is thousands of feet away from this particular site. I'm not disputing any issues that might be there with the fire truck and that arm, but it seems to me that some of the concerns that are being raised are far more general and applicable to the entire site and not just our particular lot. Now, obviously, because of our lot, we're interested in gaining approval and satisfying the fire department, for the particulars for our site, but it seems as if there's some wider general concerns that are being raised now for the first time after we've had many, many approvals in this particular area. So, we can work forward, dealing with the issue and passing it on, but we represent this particular lot owner, not necessarily the Arthur Kill Association. We can reach out and try and put various parties together, but I just want to make it clear. It seems to me that there's definitely a separation here between larger issues and site-specific concerns.
Right, but so this is, again, the classic Staten Island problem, right? It's somebody else's problem. It's my house or my place, and I shouldn't have to deal with somebody else's problem. This is where your client, it gets caught between the issues, and that's where the client, the property owner, has to reach out to the association that's responsible for maintaining it and saying, effectively, you're depriving me of the right to develop my property because you're not properly maintaining the roadway, which is the responsibility of the association. So sure, when we see the associations are falling down on the job, that's kind of what underscores why these unmapped streets are such a terrible idea. But on industrial loop, you have a long history of industrial development. But if the fire department is now encountering issues that raise significant concern, you can't just ignore it and say, go forth, right? It
No,
means,
perfect.
right?
So if anything is provided to us, we'll definitely pass down both to our particular property owner and any large organization and address any of the fire department concerns. You know, whether they're site specific or something more general. So pending receipt, there's nothing that we can specifically respond to right now.
Right, right.
Well, Mr.
But,
Dan, do you have a contact information at Arthur Kill Association?
I will try and find one, and you and I can definitely communicate.
Okay, great.
Once I get that.
Then
We'll be in touch.
maybe what I can do is arrange for the borough commander for Staten Island to the two of us would meet with this members of the association and see if we can sit down and discuss what they can do to better police the site. And then if we're satisfied, we can release an approval, a letter of no objection for your client.
Understood. And yes, we'll definitely work on that.
Okay, thank you, sir.
Okay, great. So any other comments from anybody? Commissioners, staff?
I just want to note that, I have a little bit of a mixed feeling on this one, partly because this loop has been there for a long time, and pretty much every application that has come before us has received in the past approvals from various agencies. And I think, at least ever since I've been on this board, all of these buildings have had to provide some kind of a fire suppression unit or something like that within their building also. So there's there are fire sprinklers or other suppression units that are there that ensures the fire is not going to spread that much. And each one of the property owners is making sure they are adhering to that responsibility. Now, what happens with the loop, which is the larger association, I'm a little concerned, that the association's issue is being, that's a separate discussion and that should be resolved. I'm not saying it shouldn't be resolved, but I don't know to what extent we can hold that against an individual applicant who is ensuring that their building is meeting all the requirements that we have put forth or what all the other regulations have put forth, and are providing the necessary access and everything.
So up until now, we've gotten sign-offs from fire department on industrial loop, right? And
Yeah.
It follows their inspection where they haven't seen problems. But when they go and they inspect a site and now they find problems, how can we ignore the warnings of fire department that you have a fire hazard situation? How can we actually do that? And the other thing that I want to say is, the longer we work on these GCL 36s, which frankly have been a bad idea since their inception, the more we learn how difficult it is to enforce or to get the responsible parties to live up to their obligations. And so when we're confronted with a situation where the responsible parties are not living up to their obligations, I don't see how we can ignore it. So this is an opportunity to step in with Arthur Kill, which we've never had to do before because we thought they were doing a good job. And if this app, and the only way to put pressure on them is a property owner who is put in a difficult position where he can go, he's one of the owners who is the beneficiary of the easements and all of that. And so that person can go to the association and say, you're preventing me from doing anything. And that's clout. He has actual legal power to enforce the association's behavior, whereas nobody else does. This is like an opportunity to seize. Nobody else has the power to force that obligation to be complied with. That's my feeling about it. So otherwise, and I don't feel comfortable about hearing the fire department saying, the forest is going to burn down, and we say, oh, well, it's a forest.
No, I don't think that's what's being said. What I'm trying to say is that the building itself and the site itself, I mean, there's the larger site of the industrial loop and there's the subject site. And it's the FDNY's concern is valid when it's looking at the larger area.
But we have no control over the larger area, none. Nobody does. That's the point about these GCL 36s. Nobody does. And the only person who has any legal control is a property owner negatively affected by the failure to act on the part of the association. So, okay, thank you. So, go. Did you want to say something?
I just wanted to mention address Madam Vice Chair. The site, is in the middle of industrial loop, and we have no objection to the development of it. It just, in the event of a fire, we cannot get to that site, and so hopefully, our objection today on this application will put the association on notice that, hey, the fire department is concerned. I'll admit, the fire department should have brought this issue up years ago. Why they did not, I don't know. But since I've been promoted to represent the department, we're taking a more proactive role in doing these site inspections. Again, I do apologize to the board and to everyone else that we dropped the ball, but we are now running with it, and we do want to work with everybody. But this is becoming a concern for us, especially in the southern part of Staten Island, with all the forested area that they have down there, and also other industrial sites that down there. And while Staten Island has not had problems with wildlife fire compared to out west, we're lucky there. One day we may have a big fire in the forested area, which will cause a lot of problems. Again, if Mr. Dale can provide us with a contact person from the Arthur Kill Association, the borough commander and myself will meet with them and see if we can come up with a resolution, and hopefully in the future the association will be more better police themselves for this site.
Mhm.
Thank you.
Okay. Commissioner Shabeta, did you have something you wanted to add?
I just wanted to thank Chief Dale for taking these serious issues and bring them up. Now is better than not.
Mhm. Yes, agreed. Okay, and as you know, a lot of agencies, DOT, for example, school safety, just to use as an example, a few years ago, we didn't have a school safety review of schools, and now we do, and it makes a very big difference in the quality of the review of a project. So, good. Okay, so yes, so we open this up to the public for dialogue. We didn't do this already? Okay.
Oh, gosh. So once again, this case is 2019-68A, 235 Industrial Loop, Staten Island.
Okay. So Mr. Dale, other than the DEP master plan, and of course, working things out with fire department, which I'm sure there'll be some sort of agreement. Fire department believes in working something out. So I think we could, I don't know how much time we're talking about really, maybe 8 weeks or something for a little back and forth with Arthur Kill and some.
I don't know, the particular timing. I mean, obviously from the purely application specific item we need to submit, we'll be able to submit this week.
Yes.
Again, I don't know the timing. I would just say, maybe 6 weeks or something like that was my guess. It depends on what the board's, schedule is. We can be flexible. I would just say, I appreciate Vice Chair Chanda's comments. Our primary responsibility is to this particular property owner, and we believe that this meets what has previously been granted and approved by both the board and the fire department. That said, it's not exclusive to working towards a bigger picture issues, and we'll do our best to, provide, that information to the fire department, above and beyond the particulars of this application.
Okay, and I think, it's fortuitous that it's your case. I think you will do well with the negotiations, so.
We'll do our best.
Okay,
Thank you, Counselor.
okay. Thank you very much. Thank you, everyone.
Thank
So
you.
nobody has called in, so I think
We're done.
Okay.
Okay,
Yeah.
so this could, oh, I'm sorry. Anything else?
No.
Okay, so this concludes the public reviews, the public hearing for June 2nd, 2020, the 10 a.m. session will resume at 2 p.m.
Thank you, everyone.
Okay,
Thanks for calling in. Bye.
bye.